for joining us today in this lecture class. I am Tulip Kant, moderator for the session, and I am deeply honored to have Ms. Aishwarya Bhati and Ms. Nandini Gore as our esteemed speakers. Thank you all for joining us today in this lecture class. Ms. Aishwarya Bhati is the Additional Solicitor General of India. We congratulate her for this recent appointment as Additional Solicitor General of India. She has been an advocate on record for 13 years prior to her being designated as a senior advocate by the Supreme Court. She is the youngest woman to be designated as a senior advocate by the Supreme Court. Ms. Bhati has served as the Additional Advocate General for the State of U.P. in Supreme Court. She has a diverse practice, and the latest leading judgment in her name is the one on grant of permanent commission and command roles to women officers in the Indian Army. Ms. Gore is a senior partner at Karanjawala Co. Ms. Gore is an advocate on record at the Supreme Court of India with an experience bar, special litigation, corporate and litigation practice. Ms. Gore has been in the chambers of Asia West for her outstanding service in the litigation. Recently, she was awarded Super Award by the World Women Awards 2020. She also ranked by litigation amongst top 100 litigation lawyers. Ms. Gore is valued by clients pragmatism and professionalism in the field of litigation as today's lecture class practice and procedure in the Supreme Court. This class is by Legitquest, an artificial intelligence research project. It is a state-of-the-art research platform conducting research very well known introduction with only one system. Case in short, diagram powered by artificial intelligence, improve fact reasoning, and this research started with interview and serve holders of so today will be for Q&A session. I would request all participants to be on and without the call, all questions can be written be taken at the end of the time. I would now hand it over to Ms. Bhati.
Am I audible to everyone?
Yes.
Tulip, you are not very audible. You were breaking up. I don't know, was it breaking only for me? I was just trying to see, but you were not very audible. If I'm audible, I can start.
Okay, ma'am.
There was a problem from Tulip's side, but now I can hear you. Yeah.
Okay, ma'am. Okay, ma'am. So very warm good evening to everyone. It is a great privilege indeed for me to be here today. Nandini ma'am has been an amazing senior colleague with us. We have all been inspired by her journey, seen how she has taken off and how beautiful that journey has been. And yes, for me today, it's a very special personal note. Karanji has been a wonderful colleague, younger colleague at the bar. But yes, today is a special note for me because I've recently been appointed as ASG, and this is my first webinar as Additional Solicitor General. In fact, I must apologize that I requested for a change in date. I had to travel back from Rajasthan, and it was creating some coming in the way of my journey. With all flights and everything gone, we had to rely on the travel by our own cars. So anyway, so the topic for today's legit class is the practice and procedure of the Supreme Court of India. Thankfully for us, we have, I have been practicing solely in Supreme Court. That's where I started. And I must take you to what we see every day when we enter the Supreme Court. The motto of the Supreme Court of India is Yato Dharms Tato Jai. In fact, it is slightly removed from the national motto, which we find in all other courts across the country. That's what we see in all high courts of the country. That's what we see in judiciary across the country, which is Satyamev Jayate. But slightly differently, the motto of Supreme Court is Yato Dharms Tato Jai. And if we translate it literally, what it means is where there is dharma, there is victory. Now, dharma for the motto of Supreme Court is not what we understand as religion. No, the real meaning of dharma, and I think there is really no equivalent word for dharma in English, and therefore we have to continue to use dharma, because dharma doesn't mean just it does not have religious connotations at all. It means, to give you an example, it means dharma of a mother to the child, dharma of the child to the mother, dharma of somebody being a sister, somebody being a brother, somebody as a father, somebody as a colleague, as a professional. You have a dharma to the profession that you choose, and dharma to your colleagues. So dharma is something that actually encompasses everything, every aspect of our working. And it's very beautifully quoted, it's very beautifully written in the Supreme Court as Yato Dharm Tato Jay. And that is why the different jurisdictions of Supreme Court, briefly I will touch some of the jurisdictions of Supreme Court, but I didn't want to keep this too much of a theory class. Books are available to all. Supreme Court rules are available for all to see. I wanted to bring in some aspects of my experience here, and that is why just after giving a few anecdotes with regard to the kind of jurisdiction Supreme Court has had, I will take you to the experiences what is my learning for the last 22 years of my standing at the bar in the Supreme Court of India. So just to give you an idea of the jurisdictions, because it's a class, so just to cover some of the aspects, the academic aspects of it. Essentially, the jurisdiction of the Supreme Court can be divided into 5 parts. The kind of jurisdiction that Supreme Court has is original jurisdiction. Then there is appellate jurisdiction. Appellate jurisdiction is further divided into criminal appellate jurisdiction and civil appellate jurisdiction. Then there is the original jurisdiction. When we talk about original jurisdiction, is essentially between 2 states. These are disputes which originate in Supreme Court of India. So they can be, essentially, these are suits under Article 131 of the Constitution, where one or more states are arrayed as a party on one side and one or more states on the other side, or the union on either side. So these litigations come directly to the Supreme Court of India. That's the original litigation. The other kind of litigation is the appellate jurisdiction. Now, appellate jurisdiction again is divided into criminal appellate jurisdiction or civil appellate jurisdiction. Now, these are jurisdictions which come on a certificate by the High Court. This is not, you can't go to Supreme Court straight away on an appeal. You have to get a certificate from the High Court which has heard and decided the matter, that there is a substantial question of law which needs to be determined by the Supreme Court. And after that certificate, the matter can be taken up in appeal by the Supreme Court. In this, there is also an enlargement jurisdiction of appeal by the Supreme Court, in which wherever cases in criminal appeals, wherever an acquittal by the trial court has been converted into a conviction by the High Court. And initially it was just death capital punishment, which was appealable as a matter of right before Supreme Court. But now enlargement jurisdiction has enlarged it to also include if apart from capital punishment, even life imprisonment is granted by the High Court. So as a matter of first appeal, as a matter of right, that first appeal is available. Then the other category of appeals which is available for Supreme Court is statutory appeals. There are some statutes which have specifically created a right of appeal. Now, appeal is something we all understand. Appeal is a creation of the statute itself. Appeal cannot exist without the backing of a statute. So wherever statutorily appeal has been provided, now there are various tribunals that have been set up. Many of these tribunals have statutory appeals which are available in Supreme Court. To give you an example, and the Armed Forces Tribunal provides, the Armed Forces Tribunal Act provides for an appeal from the judgment of the Armed Forces Tribunal directly to Supreme Court. So there are various statutes where directly it has been created, the appeal has been created to go directly to Supreme Court. Then the next kind of jurisdiction that Supreme Court has is the writ jurisdiction. Now, this writ jurisdiction essentially stems from Article 32 of the Constitution, which is Part 3 of the Constitution. Article 32 is constitutional remedies. And interestingly, when the architect of our Constitution, Dr. Babasaheb Ambedkar Sahab, was asked what he thought was the most important article of the Constitution. And mind you, it's a difficult question for somebody who has been who has been the chief architect of something, to ask him when one of the longest, in fact, the longest constitution of the world, Yugoslavia had a longer constitution than us, but then Yugoslavia did not survive as a country. So the longest constitution of the world, written by eminent founding fathers of our country, and the drafting committee headed by Dr. Ambedkar. When he was asked what he thought was the most important article, that difficult question, he mulled for a minute, and then he said that I feel that the most important, the soul of the Constitution, if is there in one article, then it is Article 32 of the Constitution. Because if all the rights of Part 3 of the Constitution, if the remedy itself was not exalted to the position of being a fundamental right. So we have a unique provision in Article 32 that the remedy for any breach or any abridgment of Part 3 of fundamental rights, which are guaranteed to every citizen in the country, that remedy itself has been made as a fundamental right, so it cannot be taken away. And Article 32 is widely regarded as a very important article. Now, the journey of Article 32 has also been very interesting for the Supreme Court. We saw that the Indian Supreme Court coined the concept of PIL. Now, PIL it's all very normal to us because we know it very well. It is very, very prevalent in our country, but PIL is not something that exists anywhere else in the world. It is in fact a departure from the traditional system of locus standi. It is a departure from the traditional concept, the settled system. So otherwise, no litigation can be pursued, with an exception of which is provided in the law itself. For example, a writ of habeas corpus, or if somebody is of unsound mind, somebody is a minor, there is incapacity to litigate, basically, then the options are provided. Otherwise, the concept of traditional locus standi is an unbreachable concept, and that is how it is understood in jurisdictions across the world. But in India, the concept of public interest litigation was coined to ensure that constitutional guarantees do not remain a mirage, a far-fetched aspiration, but it becomes a reality for the masses of the country, for the far-flung and the far-fetched citizens of the country who had no means or no access to justice to ensure that their fundamental rights are not violated. But that was the decade of 1970s. We also have to bear in mind that the journey of PIL itself has been very peculiar. Today, public interest litigations have become mostly about, a large part of it has become about publicity interest litigation, and it is either vested interests or publicity interests which are guiding a lot of these PILs. We also have to bear in mind that when the concept of PIL was started, then there was really no option. The option of people having access to courts was very, very little. But in 1987, after the Legal Services Authority Act, and now after legal aid there is a constitutional guarantee to it. Now it is statutorily protected, and it is available in every state, in every high court, in every district court across the country, and many municipal courts across the country. So legal aid has become a very strong concept, robust, dynamic concept, and therefore now access to justice is no longer a mirage and readily available to all. The other kind of jurisdiction that Supreme Court, of course, I took a detour and went longer into it, but the other kind of jurisdiction that Supreme Court has is the jurisdiction of contempt. Now, we all know that the High Court and Supreme Court are courts of record. That is what gives them the power of contempt. Supreme Court has the power. Now, these contempt jurisdictions are also divided into either it is civil contempt or it is criminal contempt, or and essentially it is about willful default or obstruction of justice. So in those circumstances, contempt jurisdiction can be exercised. Then is the jurisdiction of transfer. Now, transfer petitions are essentially filed in Supreme Court under three three provisions of law. In the civil cases, it is filed under section 25 of the CPC. Most of these petitions we see are matrimonial petitions. In fact, this and also the criminal petitions under section 406 of the CRPC, these both petitions are for transfer of cases from one state to another. In practice, we see a lot of matrimonial disputes being pursued by transfer petitions now, and because it is a transfer from one state to another, therefore this is a jurisdiction which is available only with the Supreme Court of India. There is another kind of transfer which is contemplated by the Constitution, and that transfer is the transfer which is a constitutional provision, and which allows for if there is any constitutional interpretation point which has arisen in any litigation which is not pending in Supreme Court, which is pending in any of the high courts, then a transfer petition can be filed directly to Supreme Court, and for transfer of those cases from the high court to directly to Supreme Court. And this under this provision, the transfer can, under section 139 of the Constitution, the transfer can come directly. Then we see the other kind of jurisdiction is the advisory jurisdiction that Supreme Court has, where the president of the country can seek advice of the Supreme Court in any manners or in matters of constitutional interpretation or any important question of law that has arisen or is likely to arise. So in either of the cases, this advisory jurisdiction can be availed of by the president. There has been some debate on, in fact, a lot of debate on what is the validity and sanctity of these, because they are termed as advices. But Supreme Court cleared the air very quickly and made it clear that while it is not binding on the president who seeks that advice, but it is binding on everybody else because it is law declared by the Supreme Court, and the advisory jurisdiction is exercised by at least five judges of the Supreme Court. It's a constitution bench that sits, and therefore it is binding for all authorities because. And now coming to, I purposely left out one particular article of the Constitution, which is Article 136 of the Constitution, which is extraordinary appellate jurisdiction. In a way, it falls in the bucket of the appellate jurisdiction, but it is very different in the way that despite all these in theory jurisdictions that we read, it is this article that sees over 90% of the work that Supreme Court does, in terms of volumes, in terms of fresh filings, not in terms of the time spent on that, but in terms of fresh filings. This is the largest volume of cases that is filed in Supreme Court. This is extraordinary appellate jurisdiction, where any order, interim order, final order from any court, tribunal, from any authority can be directly challenged before the Supreme Court of India if it raises a substantial question of law of general public importance. Then by way of a special leave petition, the petition can be filed directly to Supreme Court. That is why the wording of this is special leave petition, and only after the court grants leave that it becomes an appeal, and then it comes up for regular hearing as an appeal. But majority of the work of the Supreme Court is under this bucket. And I also must make a mention of Article 142 of the Constitution, because that is where the connect of yato dharms tato jay actually lies for the powers of the Supreme Court, inherent powers of the Supreme Court to do complete justice. That comes from Article 142 of the Constitution. Now, very little time is left. I didn't think 20 minutes will pass away so quickly, but just to sum up some parts of my experience, I'll just take 2-3 minutes and sum up. Supreme Court litigation in Supreme Court is a very, it's a very specialized kind of litigation. It's a very different kind of litigation. We have admission days, we have NMD days, which is a Tuesday. Admission days are Mondays and Fridays, and we have regular hearing days, which are Wednesdays and Thursdays. Now, Mondays and Fridays, it's like you are trying to aim at, there's a long list of not in COVID times, but in non-COVID times, there is a long list of 50, 60, 70 matters in every bench. They hear these matters, they take up for admission. Most of these are SLPs, like I was mentioning. And in practice, it doesn't come from every court, any court or any authority. In practice, they have to follow the judicial hierarchy, and it is only after going through the High Court that they can come to the Supreme Court. And otherwise, Supreme Court does not really make it a point to interfere unless it is it's an aberration, it's an extraordinary situation. But on admission days, hearings before the Supreme Court, it's a very interesting phenomena. Many of the interns don't get an opportunity to go. In fact, the Supreme Court does not allow interns to go see the proceedings on admission days because it's too crowded. It becomes as crowded as a fish market in Calcutta, I must tell you. But despite that, if you see the working of the Supreme Courts on Mondays and Fridays, you will be amazed by the kind of effort that goes behind it, where every bench has gone through every matter that is listed before them. They know exactly what the matter is. They know what exactly is the point of law. And it's a very small window that is available to the lawyer. It's like aiming on a target. If you're a shooter and you had to shoot a target, you are shooting at a target which is constantly moving, and in which you have a very small window available to you. It opens for 5 seconds, 10 seconds, and the target closes. So unless you latch on to the target in the first 5 or 10 seconds, you really have no case. That is what my experience is. So your opening line, your opening statement has to be very very well thought of, very well crafted. You have to put your best foot forward. You have to make sure that you somehow catch the attention of the bench, and then you take it forward. Also very important, mostly admission hearing days, most benches will have a question. They've gone through the brief. You can't have you can't start from facts and expect that the bench will go with it. No, they will have specific queries. If you can answer those specific queries instantly, in a manner that satisfies the bench, or then you have really no chance. You have lost it. The bench may continue to hear you for the next 2 to 3 minutes, but you have lost the attention of the bench, and then you really have no chance. So this is how admission hearing matters are. Tuesdays are non-admission hearing matters, which are actually where leave has not been granted. These are also still fresh. After pleadings, after counter, rejoinder, etc., the hearings take place. And these days are longer hearing matters. These are matters which need slightly more hearing. At the same time, leave cannot be granted, because once leave is granted, there's a different queue. Then these matters come up only on Wednesdays and Thursdays, and there's a very long queue of regular hearing matters, and these matters take time to come up for hearing. So NMD days are matters which are urgent matters, which cannot wait for leave to be granted, and they are heard like that. To end on a interesting note, an anecdote which is my own experience. One of the first matters that I went to brief Mr. Solicitor. I was a newbie. It was a brief that I had prepared very well. It was something that I was looking forward to so much that I did not want to falter. I did not want to make any mistake. I completely went through every word, every sentence of it, and I was completely thorough with the brief, hoping that I will have a good conference. And it was a celebration that I'm having an opportunity to brief somebody who's been a doyen of the bar. And with all my enthusiasm, I was a young girl at the bar. With all my enthusiasm, as soon as I went to Mr. Sarabji's office, I could not answer the first question that he put to me. I realized that it is more difficult to brief the seniors than actually to appear before the bench. And the first question that he put to me was, who are we before? Which means, which bench are we before? And I had no idea, because I had not seen the list. I was so thorough with my brief, but I had no idea where the matter was listed. And then I felt that why he's asked me this question. Anyways, his own juniors were there, his clerks were there. They answered quickly. They had seen the list. They said, we are before so-and-so, so-and-so. The rest of the briefing went very well, as I had expected and as I had prepared. But now I see that when I sit with my team of my colleagues, my juniors, and they brief me for next day's hearings when we are having conferences, I find myself asking the very same question to my younger colleagues, that who are we before? First tell me the bench and then brief me the matter. So the circle has become a full circle. The question that I could not answer as a young lawyer is the question that I end up asking most of the times these days. But Supreme Court is one incredible place. It is amongst the best of the Ivy League colleges. There is so much of learning. There is so much of experience. There's such. It is a very difficult place. It is a very cold place if you're not prepared. If you're from a small town, if you want to make a place for yourself, it is very, very difficult. But there are incredible helping hands. There are amazing people with kindness. There are so many amazing examples who inspire you every day with the way they are prepared, with the way they argue. There is so much of learning. All that you need to show is that you are sincere, you are honest about your profession, and you mean business. If you want to go to Supreme Court to just enjoy the corridors, just to have coffee and do socializing, then you can do that. But if you're there to make a place for yourself, to actually work and to bring out the best of you, then you will find so many helping hands. I'm also myself a first generation lawyer without any backup, but I did have a beautiful journey, and I had so many gurus. Today's Guru Purnima, and it's not one guru alone. Let me tell you, it's so many gurus that you find who inspire you. People who are senior to you, people who are your contemporaries, people who are younger to you, not necessarily just lawyers. Even a mason who comes to repair a water tap or a water tank can give you an advice which I hold very dear to my heart. He once told me that we were unable to find out from where the water was leaking, and he said, "मेहनत और पानी अपना रास्ता खुद ढूंढ लेते हैं." So these are the kind of lessons and learnings that are there, and Supreme Court is amongst the best of the working places. It's a journey in self-discovery. If you are thinking of practicing in Supreme Court, please make sure that you bring all of yourself. It's not possible to practice in Supreme Court just with your brain, just with your head. You have to bring your heart. You have to bring your eyes, ears, nose, hands, legs, all of you, your nails, your hair. You have to dive right into it. And it's a beautiful place. Thank you so very much. Sorry, I've overshot my time.
Thank you, ma'am. That was indeed very helpful and insightful. Now I would hand it over to Nandini ma'am to continue it from here.
Hello and a very good evening to all of you. Like Aishwarya said, that today is Guru Purnima. So first of all, I would like to thank all my gurus in my life in legal profession. So I would like to start with Mr. B.M. Tarkunde, senior advocate, late he was judge of the Bombay High Court. Then Mr. Ryan Karanjawala and Mrs. Mani Karanjawala. These three are my pillars. And yes, Mr. Adarsh Goel, Justice Adarsh Goel, I worked with him also for some time. So first of all, I want to thank them so much for shaping me out. Secondly, I would like to thank Tulip and Legitquest, which, you have given us this opportunity to speak. It is like a lecture series, but what I'm thinking is that what Aishwarya has already said about the Supreme Court jurisdiction, it is like a class. So Supreme Court rules and procedure, the book is available and you can see the book and read all the rules there. And all the rules are, connected with the Constitution of India. So I will be taking you on a different perspective. What Aishwarya has already touched, why should we repeat it? So I will start with the understanding of the practice and procedure of the Supreme Court of India, and let's understand the culmination and the evolutionary process of the Supreme Court, which started with the creation of the Federal Courts of India in 1937. So the federal courts were formally they were inaugurated by the Viceroy in 1937, 1st of October, and 3 judges took oath at that time. The first sitting of that court was held on 6/12/1937, and the federal court has a limited jurisdiction to decide cases between the central and the constituent units. The federal court was not anything like the Supreme Court of today. As said, the court sat for few days. So I was just checking the records. They sat for 9 days in a year. And what they used to decide it, very, very important constitutional question, nothing else was decided. Thereafter, the first step to abolish the Privy Council was happened. That took place in 1949 in anticipation of an Indian constitution in 1950. Thereafter, on 26th of January 1950, the federal court gave away its path to Supreme Court of India, and then the Supreme Court's constitution was adopted, and this came into force on the same day. So the inauguration held on 28th of January 1950, and they did their hearing from the Parliament building, because at that time the Supreme Court building was not there. The building was this building where we sit now these days in the Tilak Marg building. It started in 1958. Our first Attorney General was Senior Advocate Mr. M.C. Setalwad, who observed at the time of the inauguration of the court, and I'll quote and I'll read it, it is very important. It can truly be said that the power and jurisdiction of this court in their nature and extent are wider than those exercised by the highest court of any country in the Commonwealth or by the Supreme Court of United States. On the court will fall the delicate and difficult task of ensuring to the citizens the enjoyment of his guaranteed rights, constituently with the right of the society and the state. No less onerous, though far less spectacular, will be the task of adjudicating the private rights of citizens and interpretation and administration of law. So just see these words. Each and every word carries so much of sanctity, and it gives the onerous duty on the Honorable Supreme Court to take care the rights of every citizen of this country. So our Supreme Court is a marvel itself, and in changing times, its procedure is also changing with the emerging needs of every citizen, every stakeholder. May it be a litigant, may it be the part of a Supreme Court. You know, there are people who are working in the registry of the Supreme Court. There are subordinate courts under the Supreme Court. So what I'm going to explain to you is how Supreme Court is taking care of all the needs of the people and how it is catering in this COVID times also. So first of all, let's start with the small, lesson about Supreme Court. The jurisdiction of the Supreme Court can be broadly divided as under appellate jurisdiction, extraordinary appellate jurisdiction, original jurisdiction, extraordinary original jurisdiction, advisory jurisdiction, inherent and plenary jurisdiction, and I will endeavor to discuss some of the essential features, and wherever I think that case law is important, I will explain that also, and with that I will connect that how the Supreme Court is advancing itself day by day by creating new rules, because the first rules were drafted in 1966. After that, Supreme Court rules are changing with the different gazette notification. So let's start with Article 32. Like Aishwarya said, 32 is a writ jurisdiction. So the first matter which comes to my mind is Bandhwa Murti Murcha. So Justice Bhagwati was the judge who was handling this matter. At that time, there was a letter sent to the Supreme Court, and this letter was treated as a writ petition. Suo motu cognizance was taken, and thereafter the pleth of the stone crushers was discussed in this matter. With that, the judges thought that nobody can go there. So what they did, they constituted a committee. That committee was constituted under the Supreme Court rules and procedure. So rules are not strictly black and white rules, but it goes beyond that. This committee gave a report to the court, and then the court acted. So just see, Article 32, with that, a committee was formed. Then what I see in the later days, for example, in MC Mehta matter, then Environment Protection Act, there were many matters. Then coal scam matters, Manohar Lal Sharma matter. What happened? The Supreme Court started with a simple writ petition, where the Supreme Court thought that yes, it is very important. What they did, they appointed amicus curiae. They appointed different committees. Committees like, for example, Bhurelal committee was appointed in the vehicular pollution matter, and the committee was asked to give a report. when the committee gave a report, the judges were, it was like proper hearing going on, plus the committee members and the experts were also there. And with that, the Supreme Court tried to lessen its burden. Because if they would have called a panchayat type of a system, that what do you say, why this is wrong, why this is not wrong, it would have taken ages for the court to decide the matters. So what they did, in a writ petition, they constituted committees. For example, later on also in many matters, for example, in Delhi, the Sealing Act was there, and there were many places which were sealed all over the country, all over Delhi, and not over Delhi. Later on, some hotels and, commercial complexes were also. That time also what they did, they appointed a amicus, a person who's a friend to the court and who will assist the court. So the matter which would have taken ages was decided in a lesser time. Thereafter, so this is what I was planning to tell you guys, that what happens is the Supreme Court is evolving different methods. With this, I will not stop here. And in this COVID times, what has happened? In the month of March, there were many matters which people wanted to file and they could not file. The Supreme Court came out with a circular, and the Supreme Court said that, okay, don't worry. What we can do is we will extend the limitation so that everybody can file a petition before the court. E-filing was also allowed, though e-filing concept came very early. This is also part of the Supreme Court rules and procedures. So they are changing with time. The Supreme Court said that you can do your e-filing, and whatever is the delay will be condoned. At the same time, Supreme Court also took suo motu cognizance about the inmates in the jail. What they did, they said that they told all the lower court authorities, the high courts and the magistrate court, as well as the jail authorities, that wherever there are matters where the inmates can be released on parole, why don't you try it? And the advocates were told that you expedite the process and see in cases where people can be released on parole for some days, because there was a threat of this is a communication disease, and it has come to the knowledge of the court judges that this particular disease is spreading in the court, in the jail. So they said that why don't you give parole to these people? So this happened. This was another case. Then Supreme Court themselves decided to stop the hearing of the court, and they said that we will have hearing through video, this VIDO, a particular teleconferencing. This is how we are doing on Zoom, so that is a different thing. And they said that we will not take maximum number of matters, but we will take matters which are of great importance. Another thing which comes to my mind is, like in Supreme Court rules and procedure, we all know that in criminal matters, we don't have to pay any court fee. Anybody who files a petition from the jail, the jail petition will come to the Supreme Court, and the Supreme Court will appoint a lawyer for that person. An amicus can be appointed. So this is also inclusive in Supreme Court rules and procedure. Then there was another circular which came in the month of February, I think February or March, I don't have the exact date. They said that A4 paper can be used on both the sides. So you're saving paper, and also you're working towards environment. So Supreme Court is taking care of many things, which is, it is not only the rules and procedure, but other things also along with that. After that, I'll come to another power of Supreme Court, which Aishwarya has already discussed, that is 136. Now, what is 136? 136, you can file any petition before any order, any judgment passed by any court or any quasi-judicial authority. Now, what are these quasi-judicial authorities? They're like, Consumer Protection Forum, Green Tribunal. There are many. So these quasi-judicial authorities are like pari passu with the High Court. So what the Supreme Court decided, that under 136, they will not only hear the matters arising out of any civil or criminal matter, but also against this tribunal, though it is annexed with the statutory appeal, which Aishwarya said. So people file petition under 136 also. 136, there are criminal matters which are also filed. So I will discuss about a very important matter which I have noted down, and I'll just tell you about this matter. This was a matter which is called, this is State of Maharashtra versus Champalan Punaji Shah, AIR 1981, Supreme Court 1675. Mr. Ram Jethmalani, late Mr. Ram Jethmalani and Rani Jethmalani, they were appearing for the respondent. State of Maharashtra filed a petition. This was a petition where the lower court granted clear acquittal to this person, and they said that he should be released. Thereafter, this State of Maharashtra went to the High Court. They lost there also. They came to Supreme Court, and they said that you should interfere in this matter. Though the Supreme Court said that we have limited powers, Mr. Jethmalani argued that this person's trial was held up for 8 years, 8 long years. So it is not his fault. It is question of his civil liberties and Article 21 also. But when the Supreme Court went into the details of this matter, they came to know that this particular offense is a jeopardy with the economy of the country. And the court cannot take a casual view, and they will definitely interfere in this matter, and they set aside the order of the High Court. So these are the strong powers of the Supreme Court, where the Supreme Court, whenever they think that is important for them to interfere in a matter, they will definitely interfere and they will pass orders. Then Aishwarya has discussed about Article 142 of the Constitution of India. So I was reading an article written by Justice Chauhan, who was a retired Supreme Court. This is a matter called Sudeep Subhash Paratle versus State of Maharashtra, AIR 2006, Supreme Court 3102. Why I am giving AIR? So that everybody can take note. This was a matter of an engineer. Now he's an engineer and he wanted his final degree from his college. While the college was checking his degree, they came to know that the certificate of 12th standard, what he has submitted before the college, is a fake certificate. Now the matter went up to the Supreme Court, and the Supreme Court, using their power under 142, what they said is, now this person has become an engineer, he has cleared all his exams, and we will be doing injustice to this man, though it is a wrong precedent, but we feel because he is an engineer and he has studied and cleared all his, exams with flying colors, he should pay fine. He should pay fine to the legal aid committee, and his degree should be given to it. So these are the vast power of Supreme Court under 142. So what we are doing is I'm doing a lot of mediations also. So under CPC 25, there are a lot of transfer petitions which are filed before the Supreme Court, and these transfer petitions are sent to the mediation center. When they come before the mediation center and we settle the matter on whatever terms and conditions the parties have, and they are ready for a divorce, they want a divorce by consent. Supreme Court is using their power under 142, and they give the decree of divorce to these parties there and then. Though many of the judges are not using it, but maximum judges are doing it so that the parties need not go to the lower court again and file a petition. And so they are saving the time. Most important other thing which I have come to know is Article 137. It is Rule 48 of the Supreme Court rules. It is called curative petitions. One is a review petition. Whenever you file any petition, SLP or a civil appeal, and a judgment has come, you're not satisfied, what you do, you file a review petition. Now we say 99.9% of these review petitions are dismissed. But there is a new concept of curative petition. What is this curative petition? We all know there is a matter of Rupa Hura versus Ashok Hura. In this matter, the Supreme Court has given very, very important guidelines. What they said is, they can change their own judgment. They think that this is what they have given. Certain guidelines are there, which I'll read for you guys. It is very important that Supreme Court can sit on its own judgment and will try and correct it. So what is the curative petitions? They gave certain guidelines. A curative petition can be filed after the dismissal of the review petition three new judges, three senior judges, and the people who and the judges who has dismissed the petition will also be part of the this particular bench. The two grounds for curative petition are violation of the principles of natural justice and apprehension of bias, which is very important. Then the party must specifically mention the grounds taken in the curative petition, and the curative petition will also be certified by a senior advocate. He will give a certificate of fitness that you can file a curative petition, and this curative petition, if the judges issue notice, it will be heard in open court. So curative petition is also a very important concept. Then the Supreme Court itself went, one degree advance in criminal matters also. In the case of Rajiv Gandhi, what the Supreme Court said that, hanging a person is not the only solution. So they said that we convert it into life imprisonment also. And it can be done because that person will not be out, but that person will remain in court and may, repent about whatever deeds he has done. Then I have noted many other things which I feel are very important. For example, in Supreme Court previously, maybe 20 years back, I am in practice for more than 27 years now. So there was no concept of, registrar courts. What they did is, the registrars are there. So people can mention the matter before the registrar court, and the registrar court can look into the different type of pleadings. And if the pleadings are not complete, they will give time. This is just to save the time of the court. Most important other thing is what Aishwarya has also discussed about the legal aid committee. Now the legal aid committee is not only handling there are people of lower stature where their annual income is less than 18,000, and there is a middle income group where the annual income is around 1 lakh. All these people can go to Supreme Court legal aid committee, and lawyer will be provided to them. These lawyers are on the panel of the Supreme Court legal aid committee, and they conduct the cases at very nominal, trying to help at every stage. Most important other thing is the Supreme Court has also formed the commercial court. What is commercial court? They have formed a separate bench for the commercial matters to be decided. Then arbitration matters can also be decided by the Supreme Court, and the Supreme Court every day is coming out with something new. Then Aishwarya has also discussed about 139A, where matters are importance, where a fitness is given. There is another provision that anybody can file. For example, there are two matters of Article 39A and Article 39B is there. Then there is advisory jurisdiction. Advisory jurisdiction, I want to read about something which is called under Article 143. The President of India is empowered to refer any question of law, and there are certain references can be made. Though in the past only 15 or 16 references are made, but the Supreme Court is still, handling these matters. There are other things also which Supreme Court is doing. For example, Supreme Court has also, previously there were no juniors, no interns who were allowed in Supreme Court. What the Supreme Court is doing is, Supreme Court has allowed the people who are learning the process of law to come to Supreme Court, not all 5 days, but yes, 2 days they are allowing it. Supreme Court is also hiring people from the different law colleges who are brilliant and who can, clear all the exams and interview to intern with the judges. So these are also part of the Supreme Court and rule and procedure. They are day by day increasing the scope and helping people. So our court is actually a marvel, and every day they are coming out with innovative ideas. Now I want to give you certain personal things which I have, felt. when I was the secretary of the SCORA, that is Supreme Court Advocate on Record Association, there are certain big matters, for example, matters of medical college irregularities. So there was one such matter before the Honorable Supreme Court, and a cost was imposed on the parties, and the judges asked me, what do you think, madam, what should be done with this? So immediately, spontaneously, I said, Lordships, the Supreme Court is having a large footfall of lady advocates, lady litigant, and the registry is also having a lot of, lady staff. There is no sanitary napkin vending machine and no incinerator in Supreme Court. Oh, is that? Immediately a fund of rupees 10,000 from that particular, the party was told to deposit this cost before the Supreme Court treasury, and a vending machine was installed in the Supreme Court and also in the registry of the Supreme Court, and incinerators were also installed. So this is the power and the scope of our court, and I am really proud of working in the Supreme Court. Every day is a new day for us, and all our seniors, all our colleagues, and we can make it a better place for living us in this particular court. And it is a good learning experience for all of us. And what Aishwarya said, I agree that if you want to go and have a cup of tea and come back, you're not going to learn anything. But if you sit in the court for 1 hour every day, if you don't have any matter, then also you will learn a lot, not only about the procedure, but about the way you have to conduct yourself in the court. This is what I want to say. Thank you very much.
Thank you, ma'am. That was indeed very helpful. Now we'll take up the questions that we have received. The first one is, how can documents be exhibited in virtual court?
It is for me or for Aishwarya?
Any one of you can take it, actually.
So virtual court, we are still handicapped with the virtual court. Now we have got a notice that next week onward, they are going to take regular matters also on virtual court. It is going to be a difficult thing, but yes, we can do the scanning of the document. Delhi matters also. It can be done. In the beginning, there will be some problem, but definitely I'm sure that when the scanning is done and the virtual court, we can do the screen sharing. I think that is possible. Why not?
Okay, thank you, ma'am. The next question is that, do you think that the Supreme Court of India needs to further amend the Supreme Court Rules 2013 to allow more matters to be heard and decided by a single judge bench to clear backlog?
I'll take that, ma'am.
Yeah.
Definitely.
So, that has already happened. Actually, just during the COVID times, an amendment has been brought in and new rules have been brought in. Like Nandini ma'am was explaining, Supreme Court responds to situations, everything that's thrown at them, or any new situation that develops, it is responded to very, very quickly. So the rules have been amended during the COVID times, and more matters are now being heard by single judges also. And, in terms of workload, if you are on normal times, if you're saying that, more workload should be added, then I must give you one example. One bench of Supreme Court. Now in Indian Supreme Court, the courts don't sit together because of the work, the amount of workload that is there, and mostly division benches. They sit in mostly division benches, and chamber courts are heard single benches, and then there are 3 judges benches also, and constitution benches are benches above 5. You should know that on a miscellaneous day, which is a Monday or Friday, every bench takes up 60 to 70 matters on normal times, and in COVID times also there are quite at least 20-25 matters are being heard by benches. That's what has happened through the June. But just to give you an idea, we think that this is not too much. You should know that what the magnitude of the work that the US Supreme Court does for the whole year, more than that work is done by a single bench of Supreme Court sitting on a single miscellaneous day. So, and multiple benches. So just, if you compare, there are 12, 13, 14 benches sometimes which are sitting on admission day hearings. With all those benches together, the kind of work that is being done, It's a huge effort that is put in by the judges. There's a lot of effort that goes behind. What we see is just hearing of those cases in the courts, but what the effort that goes behind in preparation of those briefs by the counsels, in preparation of those matters by the bench, by the registry, it's a lot of effort. And I have no qualms in saying that Indian Supreme Court judges are amongst one of the most hardworking judges, and they have the most amount of workload anywhere else in the world.
Related to, we have another question says that how do we ensure the privacy of the parties while we are adopting virtual hearing?
So, ma'am, you want to go?
No, you go ahead, no problem.
So, there's no problem.
Something later on.
Okay, sure. So there is no problem with the privacy of the parties. Parties are not appearing in the courts usually also and virtually also. It is the counsels who are appearing. Where the party is appearing in person, there they appear. And privacy is never a problem. See, privacy is allowed to be hidden in cases where there are sensitive cases. So where there are cases of sexual, sexual abuse, sexual assault, etc. Then such cases are, we don't file by, the filing does not happen by the actual name. The filings are ABC versus so-and-so, Miss X versus so-and-so, Miss Y versus so-and-so. These are the kind of nomenclature that is used because of the, to protect the privacy of the parties. But courts are essentially public platforms. These are public spaces. If somebody has come here for justice, then it's not about protecting privacy. And there's nothing that virtual court, it's the same kind of public hearing that happens in open courts as also in these courts. So I don't think there is any problem in protection of privacy.
So Tulip, what I want to add here, which is very important, is what Aishwarya is saying about the virtual hearings which are going on. But very important question is this, that nobody should be doing the recordings of the proceedings of the court. And if you do that recording, it is definitely the privacy. If a matter is still pending before the court, it is sub judice, and somebody is recording the whole thing, and then the recording can be flashed. The way things are going in media, anybody can record it and just put it on this thing. So we have to think about it. Second most important thing, which I will quickly cover, is when we are doing mediation. Supreme Court is having a lot of Supreme Court mediation center matters where they have started online mediation now, and they're given. So one matter which I did, and there are other colleagues of mine who are doing. So I have to talk to the parties not only separately. It is called a separate session and a caucus session, where both the parties are there. When I talk to one party only, so I had to take only one party on the virtual room, the other should be out. Now, if it is on the screen and somebody is going to record it and can just keep with themselves, this is, there is an anomaly on this. So we have to think about this thing. ODR, virtual court, everything is fine, but we have to have certain strict guidelines for that so that things are not leaked out. That is my answer to this question. Thank you.
Okay, ma'am, thanks a lot. The other question is that from which year one should start practicing in Supreme Court as a law student? Also, how to start practicing in Supreme Court being a student?
I have my views on this. Maybe I'm wrong and people can take me wrongly also. I think that before coming to, and let Aishwarya also answer this question later on, I think that we should do some practice in the lower court so that we understand the CPC. So I think that we should practice in the lower court or in the high court for some years or for some months, and then come to Supreme Court, which is very, very important, so that our basics are strong.
I agree with ma'am completely. Supreme Court is the highest court of the country. It is at the top of the hierarchy of our legal system. And the learning is more if we start in courts where there is original jurisdiction, where there is, in theory, Supreme Court also has original jurisdiction that is between states and union, etc. But that's very little. I mean, it's very fractional of the work that actually comes in that. So when we work in courts which have original jurisdiction, we learn more. We also have better interface with the clients. We understand the procedural aspects better, CPC better, CRPC better, and other procedural aspects much better. So it is always beneficial to have that experience of an original court. It need not be in a in a munsif court. You can even choose to go to a tribunal of your choice if you. And these days the options are too many. Now there are specialized tribunals and courts for just about anything. So if your interest is tax recovery, debt recovery, go there. Electricity tribunal, water disputes, matrimonial matters, armed forces tribunal matters. There's just about anything and everything that's available. Please start from an original court. That will give you a better impetus. How long you stay there is something that you decide on the basis of how good you are learning and where is it that you actually want to go.
Thank you, ma'am. The question is, do you demand for the formation of a National Court of Appeal and restrict the Supreme Court only to constitutional jurisdiction?
You want to go, ma'am?
No, go ahead.
Okay, so this is also something that we all have our views on. There's no right and wrong answers, but my view is very strongly of the view that we can't have a system where we break down our Supreme Court of India. The Supreme Court of India is the apex court of the country. No other country in the world has its apex courts in compartmentalized or any other forms. Of course, there are some countries which have a separate final court of appeal and a separate constitutional court or separate chamber in that. But in India, in the legal system that we understand it, High Court is the last court of appeal. Actually, it is wrong to understand Supreme Court as a court of appeal. Supreme Court is a constitutional court. If there is a grave error, grave miscarriage of justice that has happened by the High Court, only then such cases should be brought up to the Supreme Court. And that is why, though the majority of the work of Supreme Court is actually SLPs from High Court, but if you see, that is why I was saying that admission hearing matters, the dismissal rate of admission hearing matters in Supreme Court is more than 80%. The matters get dismissed very quickly, and rightly so, because the High Court has to be the final court for a finding of fact, for a finding of law on those issues. It's only extraordinary matters that have to be heard. And actually, Supreme Court works, that's how differently. When constitutional interpretation matters come, special constitutional benches are set up. Those benches then dedicatedly do that matter only. They focus on that work and they complete that work. In the last few years and decades, we have seen that special constitutional benches have decided very important issues of constitutional importance. So I don't think we need to change or tweak anything about the Supreme Court. I think it's up to us to not bring, to not thrust too many cases in Supreme Court, but then they get thrown out if we come with litigation which is not proper to be brought to Supreme Court. It gets thrown out on day one.
So my point on this is, my take on this is that don't compare Supreme Court with lower forums or the tribunals. So I agree that we have companies court is there, so their benches set regularly in different states, or competition commission or other forums are there, so their benches are sitting. But don't compare these things with the Supreme Court. Supreme Court is one. Supreme Court is unique. Supreme Court is different from all other countries' court. We are not like a federal court. We are doing double duty of federal court as well as the appellate jurisdiction and the original jurisdiction also. Supreme Court should be one because it is supreme. Thank you.
Thank you, ma'am. The question is, what is the for applying for urgent hearings during holidays or beyond court or hearing at the judge's residence?
So there is, no hard and fast rule. Our Supreme Court has made it so easy for the parties during COVID times also, and otherwise also. Usually we know under 136 there is a time limitation of 90 days from the date of the receipt of the judgment. But otherwise also, if you have some important matter where you want the hearing to be held at the judge's house, you have to contact the registrar. Even we have the Supreme Court directory at the back of which all the numbers of all the resident as well as mobile numbers of all the registrars who are associated with the Chief Justice and other judges are there. We have to just inform them that we have a matter. We have to just file it, mention it. If the judges feel it is important, we have done so many matters that immediately a hearing is given. So I don't think so there is any hard and strict rule on that.
Aishwarya, ma'am, you.
No, ma'am has already covered it, but there is a vacation registrar that is nominated for, for every 1 month, 2 months, or 3 months. And beyond court hours, you can go there. Supreme Court has a unique system of advocates on record. I was one for 13 years. Ma'am has, of course, been there for a very long time. But advocates on record are advocates who have to clear a very stringent process, a very stringent examination. And after clearing that examination, the accountability of advocates on record is very high. They alone can file pleadings in the Supreme Court or a party in person after getting due permission. So advocates on record act very responsibly. And if such matters are there that need to be heard, of course, we may think our matter is very urgent, but then the vacation registrar you have to convince. And it's not just for vacations, even otherwise, beyond court hours, Saturdays, Sundays, if it is urgent, then you have access to the courts. But they may not always agree with you, because your concept of an urgency may not be the concept of urgency that the bench sees.
And Tulip, I wanted to add something. Sorry for this interruption. First time in the history of Supreme Court, this time the advocate on record result came during this COVID time when the court was closed. Registry was closed. And what the Supreme Court has done? Supreme Court has given oath to these people, and their registration is also done, and now they can also do filing. So look at our Supreme Court, how quick they are, and they are always helpful to us.
Okay, ma'am, thank you. That's helpful. And this other question is the concept of ex debito justitia. The court can correct its own mistake. It is not derived from any of the Constitution, but the Honorable used it in Antulya's case of 1988 and then Rupa Ashok of 2002. Nandini ma'am has covered this to some extent and something more on it.
So basically, you see, the court can correct their own, mistake is, they will correct their own, but that doesn't mean that you flood the court with different things that, oh, you are always wrong. So the Supreme Court is not going to change the basic constitution of whatever is the basic skeletal system of the court. But if they feel that there is some grave injustice done to the party, or a party is not heard, notices of after notices were sent in this Rupa Hora matter, which one party said that they never received and they were not participating in the court hearing, and they said that we were not heard. We were an important party, we were not heard, and because of that, injustice is done to us. So there are, these should be rarest of the rare cases. It should not be a common thing that everybody say that always the court is incorrect. So it has to be used very, very springly and very, very carefully. That is my view.
I just want to add something to this. See, this is one aspect that Nandini ma'am has covered. The other aspect is where interpretations of law are there, then we always see larger benches which are of larger composition. Then they can always set aside what has been held. To give you a recent example, adultery was something that was challenged at least 3 times before in the decades of 1970s, 1960s, 70s, and 80s. It was challenged on different aspects. Adultery as a section has been in the Indian Penal Code ever since Macaulay gave us the Indian Penal Code in 1860. And the language of adultery as an article it was a crime against a man, against the husband, if the wife had sexual relations with another man outside of marriage without the consent or connivance of the husband. Now just look at how terrible that definition is. But that definition was examined, considered by the Supreme Court on earlier 3 occasions. Once where, where from the victim's perspective, to take woman as a victim, to whether to take woman as an abettor of the offense, whether to take her as an accomplice of the offense. And on every occasion, the Supreme Court said that, no, it's fine, there's nothing wrong with it. And they did not quash it. But in Josephine case, recently, 2 years back, they have now made it unconstitutional. Now adultery does not exist in the statute book. It has been declared as unconstitutional. In one of the judgments, Supreme Court very beautifully said that fundamental rights are like empty vessels. Every generation has to fill in its own wisdom in those vessels as per those times. So the beauty of the process is that Constitution is a dynamic document. It continues to evolve with the times that we live in. We have seen many times that Supreme Court larger bench compositions differ with judgments that have been given. We saw this happen in the 377 case, where the Supreme Court had negated the Delhi High Court judgment in Nas Foundation, but subsequently they did say that 377 cannot, if there is a consenting relationship between two adults in the privacy of their homes, then the crime has no business to be there. So we've seen many times that the interpretations do get changed, and that's the job of the Supreme Court.
So the Supreme Court and the judges and the lawyers, we have to act collectively, and with the changing time, with the modernization of the society, with the modernizations of different concepts and different rules, the Supreme Court also is having, some judges who are revolutionary and some lawyers who are also revolutionary. So law is a process of changing as well as the law. So also keeps on changing. We have seen in Nirbhaya case how the interpretation was done, what Nas Foundation matter, how the thing changed. So it is just like we say, evolution of man. It is like evolution of law. So it keeps on changing. Thank you.
Thank you, ma'am, for that. The other question is, what should be the requisites before reaching an advocate of the apex court for working under him or her? And how should one plan for his or her career?
Again, I would like to say that first you work in some, different forums, like Aishwarya was saying, a tribunal or a high court, so that your basics groundwork, because when you come to Supreme Court, you have less interaction with CPC, CRPC and other, the text, what we call the bare acts. People hardly see the bare act, because what I feel is in a Supreme Court, in a, miscellaneous day, in 5 minutes, you have to present your matter, you have to give the important points and get an order or get your SLP dismissed. So firstly, you work in some other courts. After that, if you are serious about coming to Supreme Court, that is your wish, whether you want to become an arguing counsel or you want to become an advocate on record. So if you want to become an advocate on record, work under an advocate on record for some time, see about the drafting, the research work which is to be done. And because what we see in Supreme Court is just 30% of our appearance. All other work is done in the chambers of a lawyer, where you have to draft the petition, you have to do a lot of research. First of all, when you draft a petition, you go to your advocate on record or your senior you are working, he will just say that this is not a petition, you have to draft properly. So you have to draft a synopsis, you have to draft a questions of law, you have to draft grounds. So first thing which my senior taught me is question of law and grounds should not be same. Question of law is different and grounds are different. What people mistake it. So people make 100 grounds. So you have to work with some advocate on record, get those expertise, and then once you have finished your 6 or 7 years of practice, give your letter to become an advocate on record. But if you want to become a lawyer, if you want to become an arguing lawyer, you have to see the small, minutest nuances, how to argue a matter, how to be perfect in that. So it all depends upon you. You can start with the lower court, take small matters, then go to the high court. And if you feel that you want to come and become a Supreme Court, arguing counsel, why not?
Aishwarya, ma'am, you would like to...
Ma'am has already covered anything, but I tell you that this is a profession of self-discovery. Though there are best practices which must be done, which are good to be done, but hard work and honesty, if you bring that, and whatever you want to make a new journey, you want to lay down a new path for yourself, this is the profession that allows you to do that. But make sure that you have, see, one thing I must certainly see, that this is not a profession that is that's very amenable to youngsters. It takes time to establish. When we go to the kitchen and we want to make Maggie, it happens in 2 minutes. We want to make dal chawal, that also 2 cookers, 1 whistle in chawal, 1 whistle in dal, and it's done. But if you want to make a 7-course meal, or if you want to make chappan bhog, then it can't happen in 2 minutes. It can't even happen in 2 hours. You have to prepare for several days. So litigation, the profession of litigation is like that. You are not choosing to make Maggie or something quickly, instant coffee or something. No, this is something that is going to take a lot from you. It's going to take all of you. all of your passion, all of your dedication, all of your hard work with complete honesty to yourself and every file that comes your way, every work, every small work, or every and it's not big works that happen. Big work does not even come so quickly. It takes a long time. It's the small steps. It's what you do with the small things in your life that determine how big things come to you. So litigation is that. Please understand it to be that. It's not you or me or anybody else. This journey does take time, but if you keep at it, the only thing is never let go. Perseverance is one important factor that you have to never let go, and enjoy the journey. It's going to be beautiful.
Thank you. And the next question is, factors determining of listing of applications to the Supreme Court. Is there any available for a party agree to a particular listing or delay in listing?
You were breaking up, Tulip. I couldn't hear the question.
What I was saying, that I couldn't hear the question.
Am I audible now, ma'am? Is it? Hello?
Yes, you are. Please go ahead.
Yes. What factors determine the timing of applications before Supreme Court? Is there any available for a party aggrieved by a particular listing or delay in listing?
I couldn't hear.
Okay, so I think she's asking if the parties get affected by delay in listing, then what remedies do they have and how is the procedure of listing? See, there is a normal procedure of listing of matters, applications, anything. And if you want to fast track that that listing, then you have a process of mentioning. That mentioning happens before a registrar, who's specially designated for mentioning. And if you have an urgency, you have to give a affidavit of urgency. There's a procedure that is laid down. Basically, you have to satisfy that there is urgency in that matter and it needs to be done. And if you are not successful there, then the last resort is that you go and mention before the bench and you satisfy them that there is urgency. So there is really no, I mean, the remedies are available to us. But again, the problem is that what we perceive as urgency may not really be urgency from the point of view of the court. So that is why, I mean, we have to assess our cases more objectively as advocates on record. The responsibility is very high. Assess objectively the urgency of your case, and it will be like wolf. If we cry wolf every time, then when the wolf comes, nobody is going to hear us. But if you have the reputation of a lawyer who does not cry wolf every time, but only when there is really an urgent matter and you really want to push it, then the bench also understands that this is a lawyer who doesn't cry wolf all the time.
Okay, ma'am, for that. We have many more, but due to time constraints, we limited ourselves to these. And it was wonderful to have all of you here. And anything else you would like to add in the end?
So I would like to add only one thing, that if there are some listeners of this webinar who want to become advocate on the courts, or who want to practice in the Supreme Court, or who want to practice law as a arguing counsel, hard work is the only solution. And keep working hard. Practice your brief so many times. If you're drafting something, you have to check your draft at least 10 times. If you want to argue a matter before the court, time is the most important thing. And you have to always see to it that you prepare your pointers and then explain your points before the court and read. What I see now these days, that in our time we used to read a lot of Supreme Court cases. SCC online was now, but previously we used to get SCC, SCRs and AIRs. And we used to have a judgment today, black and white copy in our office, which used to come every week with recent cases. And we used to read those cases regularly now. And when we were doing research for for example, I had to find out a particular case, there used to be a digest. So we used to look from that digest and go backtrack, or later to keep checking what is the next judgment, what is the next judgment. Now these days what I say is that you have to work on your computer and you get in one key everything. So study hard, work hard. You have to read a lot of material, not only confined to courts, the judgments, but other journals also. You have to see that what are the other, in other countries, what are the judgments on these particular point. So this is how you enhance your skill and you become a better lawyer. Thank you.
Let me end with a personal anecdote that this is the conversation that I had with my mother. My mother is an amazing lady. Last week when I got this appointment of ASG, I was with my mother, and I was actually sharing with her that how from a small town of Jodhpur I decided to go to Supreme Court, and where I am today, I could not have even imagined in the wildest of my dreams that I will be able to be in these places, in these beautiful steps and shoes that I find myself in today. And it's all I was telling my mother that initially when we started court, I did not, mom, my mother said, "Tumhari tapasya hai beta." I said, "Mom, when we started this tapasya, I did not even know how to make this tapasya. It was just, I was there and, trying to do whatever I could." So my mother told me that Valmiki ji was actually a very khunkar daku. Valmiki ji who wrote Ramayana. And when his life changed by one very big tapasvi, when his life changed, he was and he wanted to then change his way and penance and do tapasya. So that sadhu told him that, so he did not even know how to do tapasya. So the sadhu told him that if you don't know how to do tapasya, just sit at one place and say Ram Ram. Valmiki ji was such a dreaded dacoit, and he had done so many wrongs in his life, killed so many people, that he could not even say Ram Ram easily. So that sadhu told him that it's okay, you say Mara Mara, but you say it continuously and do not stop. You continue to say Mara Mara. Valmiki ji sat down under that same tree where he met that sadhu and started saying Mara Mara, and he said it with so much of dedication, and he said it so continuously without giving up that Mara 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 actually became Ram Ram. And several years later, when that same sadhu came and he was looking that did he actually, did he take my advice? Did he do that tapasya? He could not find any man anywhere, but he saw that there was an ant hill under that tree, and that ant hill was in the shape of a man sitting. And under that ant hill, then when they dug, they found they did not dig under it, but they heard that there was some murmuring going on inside. When they heard closely, there was the sound of Ram 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 being under that. And when they dug it, it was same Valmiki ji there, and Valmiki is actually the ant hill. So that is how the name Valmiki was given to him. So my mother said that even if you did not know how to do it, if you have done it with dedication, then that dedication counts. And I hope you all can bring the dedication to something that you dream of, something that you want your life to be.
Okay, ma'am, thanks a lot for such a wonderful ledger class that we had today and for your exceptional, insightful views. And congratulations to Ms. Bhati again. And for the recording, kindly subscribe to LegitQuest channel. And I would also thank all the attendees for being with us. Thanks, and stay safe, everyone. Thank you.
Thank you so much.
Thank you. Thank you.
Thank you.